bring it to your attention. I think the only other area that I really want to deal with in my paper is the Interest Act, because it's a problem that can or might give you very serious problems. In the recent past, because the interest rates getting so very high, lenders and borrowers were coming up with very complex formulas, and you'll remember one transaction that I'm talking about, and methods of trying to get fair market yields to their respective clients. And the definitions are so complicated that one must look to the Interest Act and see whether you fall within any one of these particular provisions. Because in many cases, you really have to stretch the language of the Interest Act in order to make sure that your transaction falls within it. If it does not, and you're asked to provide an enforceability opinion, which is always the case in these kinds of transactions, you're riding on very thin ice. Again, I just draw it to your attention as a matter that you must look at. Similarly, the whole area of equity kickers and participation clauses, etc., that was in vogue within the very recent past, raises the whole question of criminal rates under the criminal code. And the effective yield to the lender may be such that you're coming awfully close to that rate, however high it might appear when you look at the section. Again, something just to keep in mind. And lastly, there's the whole area of letters of credit. It's a new phenomenon as in the commercial real estate area. When I say new, it's grown very much over the last number of years, that every covenant that is being delivered in a commercial real estate transaction be supported by a letter of credit. That is an area of tremendous complexity. All I want to warn you about in the delivering of an opinion in respect of a letter of credit is that there are circumstances, there are cases, conflicting cases, that indicate that there are circumstances when those letters of credit may not be honored. And I think, again, that you ought to be aware of that, and that you ought to try and protect yourself in the opinion by using the appropriate qualifications. And you can see some language that I've got to that effect in the materials. I apologize for going over my time. Indeed, I think that you now want to have a panel discussion. Just go ahead. Pardon? I've already introduced the panel, and if I can get started by asking a question to Paul Carroll. Paul, sometimes lawyers try to limit the scope of their opinions, expecting thereby to reduce their liability. Do you have any observations on where the onus lies in determining the scope of an opinion and the resulting liability?
Thank you, Don. This is, of course, a totally unprepared question. I think the answer to that question is quite simple, that the onus lies on the lawyer who's giving the opinion, with one possible semantic distinction that I'll make in a minute or two. First of all, I'd like to read an excerpt from the Canadian Bar Association Code of Professional Conduct, which states that the lawyer must be both candid and honest when advising his client. That's the basic rule. And the commentary on that is that the lawyer's duty to the client who seeks legal advice from him is to give the client a competent opinion based on a sufficient knowledge of the relevant facts, an adequate consideration of the applicable law, and the lawyer's own experience and expertise. The advice must be open and undisguised, and must clearly disclose what the lawyer honestly thinks as to the merits and probable results. The lawyer should clearly indicate upon what facts, circumstances, and assumptions his opinion or advice is based. There are also a couple of cases that take that principle really into the question of the ultimate liability for giving the opinion. And one case is, and these are Ontario cases, is Major and Buchanan, which is 1975 9 OR 2nd 491, which stands for the proposition that there is a duty on the lawyer giving the opinion to advise his client of all the relevant risks. And that's modified to some extent by another Ontario case called Brenner and Gregory. I think the defendant in that case is fairly well known. 1973 1 OR 252, which stands for the proposition that the lawyer is not liable if the client, of course, knows the facts equally well himself, which oftentimes in commercial real estate is the case. So those two cases have to be read somewhat together. So I think that the point there really is that the liability, the ultimate liability for giving any opinion, which I suppose in a sense is where the lawyer starts his inquiry, what am I ultimately liable for, will depend upon the scope of his duty to his client, and that obviously depends to some extent on the facts. But I think the basic principle is that the client is entitled to expect the lawyer to have done an adequate review of the facts and all relevant circumstances in order to give him that opinion which is appropriate to the circumstances. Where I find in terms of opinions, spend a lot of my time negotiating opinions that are obtained on financings, and I tend to write a few of them, and I think we all tend to ask for things probably that are a little unreasonable, and there's some center ground where you end up settling the form of the opinion. But one of the areas that, depending on which side you're on, always seems to be the subject of negotiation is the scope of, or the stated scope of inquiry in the opinion. And the lawyer giving the opinion always tries to say that I relied on the following 8 things. I think the theory being that you're somehow limiting your liability by restricting yourself to that stated recitation of facts. The person who's receiving the opinion, normally the lender's counsel in the example I've given, tries to get the broadest statement of what the lawyer giving the opinion has done, namely, I've done everything I thought was reasonable under the circumstances. I think that the latter, the more general recitation of the factual background for the opinion, and when I say factual background, is also legal considerations that go into giving the opinion, is the appropriate way that in which an opinion should be framed. If you are successful, or if the person giving the opinion is successful in restricting the list to a given recitation of facts, I think that there is an onus on the lawyer giving the opinion to make sure that the person receiving the opinion clearly understands that that is a complete scope of inquiry. And I think that you don't escape ultimate liability by being successful in having a limited statement of the scope of your inquiry, if that possibly may have overlooked something which if the client were aware of it or the person receiving the opinion were aware of it would have put him on some inquiry. I think it's improper as a form of opinion giving that the person receiving the opinion, even if that person is another law firm, for example, or a person who may be technically qualified, if that puts that person on the onus, but if that tries to transfer the onus to the recipient to have, in effect, asked the right question. I don't think that any law firm asking another law firm to render an opinion should ask that firm to give an opinion that they wouldn't be prepared to give themselves. Now, there may be circumstances under which either that law firm, the recipient law firm, may not have the factual background, or it would impose upon the client a considerable expense for that firm to obtain that factual background. There may be circumstances under which the onus can be left with the firm giving the opinion. But I think basically speaking, you should not expect another firm, another lawyer to give an opinion that you aren't able to give yourself. And I don't think that you escape the liability by transferring to somebody else the obligation, or at least the upfront obligation of giving an opinion if you have any any reason to question the veracity of the opinion. There's a few specific examples which I might just mention of where I think an onus comes out of either statutory provision or a set of facts, and one is the one you've mentioned, Don, the Land Titles Act. I think Donahue will go into this in more detail in a minute, but I don't think you've achieved anything by giving a blanket statement that your title opinion, or this may lead into a mortgage security opinion, is subject to the exceptions of the Land Titles Act. What are they? I don't think that it's appropriate for you to assume that the recipient knows what they are and may not realize some subtlety of why a particular exception in a particular case is relevant. I think the onus is on the person giving the opinion to make it clear in the opinion just exactly what the exception is that's being stated, if there is one. The same comment can be made about your reference to exceptions in the original Crown patent. What were they? Another one would be the Personal Property Security Act, the requirement for renewal of registration. I think an opinion that says that, in effect, says that the security is such and such priority without going on and making the statement that there is a renewal requirement in a certain period of time, and that's not the only statute with that arise, but it's certainly one of them. I don't think that's a proper way. I think there should be a statement in the opinion that transfers or satisfies the onus of bringing to the attention of the recipient the fact that there is a renewal requirement. Another one that arises out of the Ontario Business Corporations Act, when, and this is section 49, in circumstances where opinions are given as evidence of compliance with requirements of certain trust indentures, there is a requirement that certain evidence of compliance be given. And it's interesting, the statement of what the scope of that is in the case of the legal opinion is that the opinion must describe the nature and scope of the examination or investigation upon which the opinion is based. And then the more important wording, I think, is, and must declare that the firm giving the opinion has made such examination or investigation as he believes necessary to enable him to make the statements or to give the opinions contained or expressed therein. In other words, the onus is on the person giving the opinion to state, in fact, to have done the investigation sufficient to have satisfied that onus. And then one last exception I might make is, or specific example I might give is the so-called due diligence defense in the Securities Act. And I guess to put this in a real estate context, oftentimes title opinions are a requirement, in fact usually are, for MERB financings, for example, where there may have been a prospectus. And it is a defense to a lawyer who may be sued for a misrepresentation which comes out of, say, a bad title when he gave a good title opinion. And the defense is that he failed to conduct such reasonable investigation as to provide reasonable grounds for a belief that there had been no misrepresentation. So I think the onus is on the lawyer to satisfy that obligation.
Thanks, Paul. We've now had 2 or 3 references to the Land Titles Act and the problems that one might get into if you're acting for a lender, for example, in accepting a title opinion that would have contained in it an exception regarding the qualifications under the Land Titles Act. Don, maybe you could just elaborate a little bit on the responsibility of the parties to such an opinion.
I think we all do it, and we're all used to seeing it, that your title opinion is subject to the exceptions and qualifications in the Land Titles Act, but I'm not sure that some of our commercial partners in the bigger firms who get that opinion from their real estate partners have thought recently about what that covers. I will just quickly go through the exceptions in Section 47. Section 47 of the Land Titles Act says that all registered lands are subject to the following liabilities: liens for municipal taxes and water rates and provincial taxes, any right-of-way, any encroachments from neighboring properties, in other words, that might have been shown by a survey, any lease for a period not exceeding 3 years, any rights of a spouse under the Family Law Reform Act, any right of expropriation, any mechanic's lien, any public highways, anything under Section 29 of the Planning Act. Now, when you take all that out of your title opinion, there's nothing left. I hope you all realize that the Land Titles Act in Ontario, which is supposed to be a guarantee of title, is a nullity. It's subject to all of that. If there's a breach of the Planning Act anywhere in the chain of title, it doesn't matter what the Master of Title says, there is no title. If any corporation in the chain of title had lost its charter prior to granting title, there is no title, no matter what the certificate says. So surely we did not intend, when we say that, subject to the exceptions in the Land Titles Act, that we as lawyers didn't have to look at any of these things, didn't have to check municipal taxes, didn't have to look at the survey, didn't have to search adjacent lands to make sure there's no breaches of the Planning Act. Didn't have to look at the chain of title to make sure that the Family Law Reform Act had been looked after. Well, if we don't mean that, then why are we saying it? It really puzzles me. I mean, you could list any number of statutes. You could list the 38 statutes in Ontario that give, or 58 or whatever the number is, that give rights of expropriation. I'm sure that no court would excuse a lawyer from doing these things in a normal transaction, a purchase, if he said that. After all, he has a duty. The courts have certainly said that. He has a contract. The agreement of purchase and sale contains reference to most of these. But it could well be that in a commercial situation where you have 2 experienced counsel negotiating the terms of the opinion, surely the one who's receiving that and who doesn't question it is considered to be aware of the holes that are in that opinion. You know, often, you spoke of title insurance, so often I think we all try to persuade Americans that they don't really need title insurance, particularly when the land's in land titles. If we ever showed them Section 47, I think they'd leave the country entirely, because the land titles certificate simply doesn't mean anything anymore.
Thanks, Don. Judy, you recall that I referred to the recent amendments in the Ontario Business Corporations Act. I wonder if you could just give us a short dissertation on what that might mean to changes in practice in Ontario.
Yes, I'd be happy to, and we're dealing with Section 183 of the Business Corporations Act. This will arise perhaps most often in your practices in mortgage or financing transactions, but it may arise otherwise as well. But the section says that the articles of the corporation are deemed to state that the directors of the corporation may borrow on the credit of the corporation and mortgage the property, among other things, without the approval of the shareholders, unless, and it's the unless that we're going to turn our minds to, unless the articles or bylaws of the corporation or a unanimous shareholders agreement provide otherwise. So the questions which we want to cover today really are, what inquiries should you make as to whether there is a bylaw or a unanimous shareholders agreement that does provide otherwise, and what's your liability if you don't get enough information, and what should you say in a title opinion to lenders after you have made, with any luck, due inquiry. Now, a couple of preliminary matters. First of all, you would want to look at Section 108 of the Act to see what a unanimous shareholders agreement was. And I'm not going to take the time because that's really more a corporate matter, but you would look to that section. The other thing, for those of you who do not deal often with federal corporations, the Canada Business Corporations Act has virtually the same section in Section 183 as well. And we're also going to look at Section 19 of the Ontario Business Corporations Act, and you'll find that Section 18 of the Canada Business Corporations Act is virtually the same, although not exactly. Well, what inquiries should you make? Up to now, we've all asked for a certified copy of the borrowing bylaw of the company. That will undoubtedly phase itself out as people realize that the law has changed. And instead, what should you get? Well, if you look at Section 19 of the Ontario Business Corporations Act, you'll see that a corporation may not assert against a person dealing with the corporation that the articles, bylaws, or a unanimous shareholders agreement have not been complied with, unless or except when the person has known or ought to have known by virtue of the position or relationship of that person with the company of what is in the bylaws or the shareholders agreement. And I think that helps us in deciding what we should have. I've canvassed 2 or 3 people as to what they are doing, and some say they are getting statutory declarations, others are saying they're getting a certificate. I think it is better to get a certificate than a statutory declaration because I think that the certificate is provided for in Section 265, which sets out who may sign a certificate on behalf of the corporation. And it seems to me if a certificate is signed on behalf of the corporation by a person set out in Section 265, that then that certificate would come within Section 19 and the indoor management rule, which is codified, I guess, really in that section. So I think at a minimum you need a certificate stating that the borrowing bylaws of the company, that there are no bylaws of the company which restrict the borrowing of the company, and that there is no unanimous agreement of shareholders that restricts the borrowing of the company. Now, you might also consider whether you want certified copies of all the bylaws of the company, but suppose the person who certifies doesn't give you all the bylaws. Is that any better than the certificate of the same person saying that there isn't any bylaw restricting the borrowing? You might also, in relation to the unanimous shareholders agreement, want to get a declaration by one of the shareholders saying that they hadn't ever entered into an agreement restricting the borrowing power. But frankly, I think that's overkill, but those are possibilities for you. The next question is, what's your liability if you fail to get sufficient information? Well, I think it's relatively obvious. If you don't get adequate information, then I think you will be negligent, and I think you'll be writing to the Law Society. What should you say in your opinion to the lenders? And I think when I was asked that question, I gave the natural reaction of all solicitors, and that is as little as possible. But as with the other things that have been discussed today, you will probably want to say that you have assumed that the certificate obtained is authentic, and that you've relied on that certificate in giving your opinion. You should also, I think, and I think this is perhaps even more important, indicate that you have no knowledge of whether the lender is a person who has or ought to have knowledge of any restriction on the company's borrowing rights, because a lender might be in very close relationship with that company and might actually have knowledge. And of course, you don't want to be in a problem if the lender is determined to have that knowledge. So those are the kinds of things I think you should put in your opinion. And that actually answers the question, but may I say one thing about the Construction Lien Act, and that is that Brenda Duncan, who's the staff person in the Law Society staff, charged with assisting the committee that is dealing with the Construction Lien Act, is here today. Brenda's in the Practice Advisory Service. Some of you may have already talked to her. She and Alan Marshall field all of the questions that people send in. She's in the third row over here, and I know that the committee would welcome a knowledge both of any of your problems and your comments about the Construction Lien Act, and you could give them to Brenda today, I'm sure.
Thank you, Judy. If I can, I'd like to just comment on one of the points that you've raised on the type of information that you should receive. You referred to a certificate, and you talked about getting that as opposed to a statutory declaration. I just wonder, and I question whether or not the question that's being asked, whether or not there is a unanimous shareholders agreement or a bylaw that might restrict the borrowing power of a corporation, I wonder whether that's a question of fact or a question of law. And if it is a question of law, I wonder whether it's appropriate to try and satisfy it through a certificate of an officer, for example, or whether or not it may be that in Ontario now it's essential, from acting for the lender, to get an opinion of borrower's counsel that to the effect that there is no bylaw or unanimous shareholders agreement in addition to or in lieu of these kinds of certificates. I'm sorry I didn't raise this with you before. I hadn't.
I don't know how the borrower solicitor can give that.
Well, it would seem to me that
they don't have personal knowledge. I think it's a question of fact.
It would. Well, the only reason. Well, that's fine. Does anyone else have any views on that?
Not sure if it's a view, but there's another example of trying to foist onto the lender's counsel that which presumably the borrower's counsel is just as able to do. If it's a question of law, it's a question of law based presumably on some facts.
Well, no,
either counsel could answer the question.
Well, the difference is this, and I know I made that point right at the outset. The difference is this, that in dealing with a corporation, and particularly a major corporation, there will be a great number of bylaws, for example, that may or may not have been amended or otherwise dealt with in the corporation throughout its history. It would seem to me much more appropriate to have the borrower's counsel, who has been involved with those various documents throughout history, give that particular opinion. as opposed to the Lenders Council doing an independent study. That's the only reason I suggest it, because I do recognize it inconsistent with what I said at the outset. I don't know, Don, do you have any view of that? No?
But I don't think the Borrowers' Council can do any more than say, I've examined the following bylaws, and in the following bylaws, there is nothing. I don't think of their own knowledge they can say any more than that.
Well, again, I'm not sure what the answer is to that, but it's an issue that obviously will have to be developed. You may have noticed that in the most recent What's New and Old and Ghastly, or whatever the appropriate name is, there was a short reference to this problem. And I'm sure that over the next little while, some form of answer will come out that I hope will satisfy the profession. We seem to have gone over a little bit, for which I apologize. I hope I don't limit unduly the number of questions that any of you might have, but if I can invite any questions, I would be pleased to receive them. Yes, sir.
On this discussion, now the codification of the indoor management rule, does it not make more sense to not get anything? And then if you're concerned that because you're a lender, you might be a person in a special relationship or who ought to know, isn't then doesn't the pendulum shift entirely over the other side when you and your counsel have to go right in there and examine all the bylaws and get certificates as to whether or not the shareholders agreement to do the full examination yourself, not just rely on a certificate? I mean, you're either one side or the other.
Well, I would prefer myself to have a certificate, to feel that I had done some investigation, that I had something to rely on, but your point may be equally valid. It's something not determined.
Any other questions? Yes, sir.
I think if I could attempt to repeat the question, I made reference to the renewal requirements of the Act, but there are other requirements which may require the filing of a financing change statement. Why not bring those to the attention of the lender? I'm not sure if it's a complete answer, but the only one I can think of at the moment anyway is that at least you know that you're going to have to renew. And that's something that I think you'd be remiss if you did not bring to the attention of the person to whom the opinion was being rendered. I suppose it can't hurt to say, except I think it does tend to burden the opinion, but I don't think it could hurt to say that there are other circumstances which might also give rise to that requirement. But I think the point is that it's something that you know has to be done. I'm assuming that the security is intended to go beyond the 3-year period.
Are there any other questions? Well, thank you very much.
Is on opinions in connection with financing and other business transactions. To lead the session, we have Gordon Coleman, who's sitting at the center of the table. Gordon is a partner in the Tory law firm. He has practiced corporate commercial law for a number of years with an emphasis on securities law and corporate finance. He has been actively involved in legal education for many years. He's the author of a number of articles in the mergers and acquisitions area, and most recently was a member of the committee which has reported to the Ontario Securities Commission on Ontario takeover bid legislation. Gordon will introduce the other members of the panel. Gordon?
What we thought we would do is vary the format a little bit and simply have a panel discussion and raise some questions, which will undoubtedly raise questions in your own minds. On my immediate right is Peter Beattie, of the McCarthy firm, who has practiced actively in the corporate finance area throughout a number of years, and I've worked with him on a number of transactions, as I have with Purdy Crawford of Osler, Hoska, and Harcourt, who is, I'm sure, well known as well to many of you, and who has similarly been involved in the corporate finance area. And what I thought we might do is deal with some critical issues that seem to have surfaced in connection with financing type opinions. I might say that this flows naturally from some of the issues which were raised by the immediate preceding panel, and indeed it ties into a number of questions which were raised in the discussion earlier this morning. The points which we're going to discuss, or at least some of them, are raised at page 187, beginning at page 187 of the materials. There are some additional questions which I think were surfaced by the last panel, the extent to which one relies upon officers' certificates, the extent to which one is obliged to review all of the bylaws of the corporation and obtain a certificate that those constitute all of the bylaws of the corporation. There are other questions which are particularly relevant to the securities area, such as an opinion that the prospectus is accurate and complete in all material respects, which I'd like to address. It's an opinion that is increasingly being asked, particularly in cross-border transactions, that is, transactions involving a public issue of securities in both Canada and the United States. There is a bibliography attached to the paper, which the memorandum which we prepared for this panel, which lists a number of articles which I think you'll probably find helpful and relevant, and addresses the issues, many of the issues which were discussed. Two of the articles by Jim Fold highlight the kind of questions that were discussed in terms of pressing counsel to give an opinion that one would be unwilling to give oneself, particularly in the banking area where there is sometimes an unequal bargaining position, and pressing counsel for the borrower to give an opinion which one would not necessarily want to give oneself may be an exercise in futility. Starting with the material in the paper at 187, and as I said, this is in the memorandum itself, this is not necessarily in any order of priority. As has been said a number of times in the discussion today, the critical opinion, one of the critical opinions that is asked for and given is that the particular agreement which is important to or basic to the transaction is enforceable in accordance with its terms, that it is a legal, valid, and binding obligation enforceable in accordance with its terms. Now, the typical exception to that opinion for many years was one related to creditors' rights, the enforcement of creditors' rights generally, and that opinion was formulated typically in the manner set forth at the top of page 188, namely that enforcement may be limited by bankruptcy, insolvency, or other laws affecting the rights of creditors generally. The tag end of that exception, which is in the third line in 188, and except that equitable remedies such as specific performance may only be granted in the discretion of a court of competent jurisdiction, is an exception which I think 10 years ago one did not commonly see in opinions.
Gordon, would you like to explain to your client what it means?
Well, I was just going to turn it over to you. I was going to simply, I'm glad that you intervened. I was just simply going to say that just to throw the matter open for discussion, that in one of the articles, Fold says that he doesn't think that opinion, i.e. the equitable remedies limitation, nor indeed the creditor's rights enforcement limitation is necessary. What do you think, Peter?
I'll just do this once. The exception for bankruptcy seems to be with us now, and I expect it'll be there for a long time. This matter of enforcement and the qualification on enforcement raises an issue that I think always fascinates me, and that is, what do lawyers' opinions mean? What do the words used in the opinions mean? And when are they appropriate? For instance, in the case of a simple borrowing of money, enforcement, I would certainly hope it's enforceable. And all this stuff about equitable remedies, I don't think comes into that issue at all. The only time I have trouble with the enforcement provision is if I know there's something in the contract that may be a problem, such as you're financing railway cars or something, and railway cars all run over a cliff and they're a pile of junk at the bottom of the ravine, and there's a provision in the contract that you will nevertheless pay rent for the next 100 years to produce an economic result for the client. So I think it's used much too often. I'm not sure what it means, and certainly the client's entitled to ask what it means.
Right. Purdy?
I note in certain of your material there's a reference to, in the list that Gordon has given you, legal opinions to third parties, an easier path, was developed by the New York City, County, and New York Bar Association to try to develop some standard wording, and if you use the standard wording, what do you mean? They suggest that if you say an agreement is valid and binding, that's tantamount to saying it's enforceable in accordance with its terms, and that you should make the bankruptcy qualification and the specific performance qualification, it being an equitable remedy for all the wording, even if you don't say it's enforceable in accordance with its terms. The conundrum you face is that the more lawyers think about this and the more they develop thoughts, the more things you have to think about what you're going to put in your opinion. For example, you say something's enforceable, you're usually directing your mind to your own client's position, and your client has enacted the necessary resolutions and done the necessary things to make the agreement, authorize its execution, and when executed, make it binding. The New York Bar says you don't have to say that you assume that it's also been duly authorized and executed and delivered by the other party to the contract, that that's an assumption you can make without spelling out the assumption. That you also maybe have to make an assumption as to no conflicting agreements. And again, the New York Bar says you don't have to spell out that assumption. It's a conundrum because as you point out in your material, Gordon, there's no sort of standard set down as to what's appropriate. Once you start spelling out assumptions, you can go on ad infinitum if you really start thinking about it. Throw the ball back to you.
Well, I think that I would also emphasize what Peter said with respect to the specific performance limitation insofar as you've got a pure and simple contract to pay money. I mean, that's all you've got.
I can't see any need for that. And the use of the word enforceable, asking for it isn't a matter of opinion, and then I know some people will not accept an opinion that doesn't say that. If you do say it's enforceable, I think it means, in the case of a money obligation, nothing more than binding, or it must be paid. And if that's the case, I don't think it's necessary to go on talking about equitable principles when the probability is if your client asked you what you meant, you'd say, well, gee, I really not, well, Ecuador, yes. There were lectures about that, but you're not, injunctions, they don't come into it.
Right. Well, moving along to the next point, the next couple of points are matters which, in my experience, have surfaced relatively recently, and they relate respectively to penalty clauses in loan agreements and judgment currency considerations. Sometimes one sees in a loan agreement a provision which provides that an amount will be paid where there is insufficient notice of a drawdown, particularly in a revolving credit agreement where there is to be drawdowns over periods of time, or providing for a payment when the conditions precedent to a drawdown are not met following the giving of a drawdown notice. We've sort of agonized about these kinds of payments, which are over and above the payments, standby payments, for instance, which are typical to revolving credit transactions. And in some recent instances, we've developed a formula which addresses this issue and which appears at the bottom of 188, and which stipulates that the opinion as to enforceability assumes that the provision for payment relating to an insufficient notice of a drawdown is a reasonable pre-estimate of damages, and the provision for a payment when conditions precedent are not made following a drawdown notice do not impose a penalty upon the borrower. I don't know whether either of you would like to comment on that.
Sure.
All right.
I think you have the obligation as the lawyer to make up your mind whether or not it is a genuine pre-estimate of damages, and then give your opinion.
So that you would say that you make the decision as to whether or not you believe it's a penalty and simply state it's a penalty and accordingly is not enforceable.
Or you may say that we express no opinion as to the enforceability of paragraph so-and-so, or paragraph so-and-so may be judged to be a penalty, but presumably all these discussions go on while you're negotiating the contract, and in most cases I think you end up being able to form the judgment that the provision is not a penalty and therefore isn't a problem, although I have seen cases where you get stuck and you then qualify the opinion.
I guess, Gord, if you're, depends on who you're acting for. If you're acting for the borrower, you may have already concluded that it's probably a penalty, and you're probably not going to say anything about it because that's probably a good thing, because you know that the lender's not going to be able to enforce it, and
but the lender's lawyer wants you to say it's okay, Purdy, so they can sue you.
Well, that, of course, raises the issue. The addressee of these opinions, of course, is not the borrower, it's the lender. And the lender should want an opinion from both the borrower's counsel and its own counsel, which is coterminous. I would think if I were the lender or the lender's counsel, I wouldn't necessarily want to push the borrower's counsel into prejudging the issue against my client. You know? The next provision relates to judgment currency. There has been, of course, an accessing of capital markets in other countries of the world, the United States, and in connection with Eurodollar issues by Canadian borrowers which are denominated in U.S. dollars. The question arises as to whether or not the opinion as to enforceability is impacted by the foreign currency denomination. And similarly, in revolving credit transactions where there is a smorgasbord of alternatives between Canadian dollars at Canadian prime, or U.S. dollars at U.S. base rate, or U.S. dollars at LIBOR rates, with the choice being left up to the borrower at each interest period as to which option it will take. And that has forced a number of Canadian lawyers laterally, and I guess laterally means within the last 10 years, to examine what the powers are of a Canadian court. Seems that fair to state that a Canadian court can only award judgment in a Canadian currency, and in the absence of a currency conversion feature, which I'll speak about in a sec, it is usual to put in a paragraph to the effect that a judgment by a Canadian court may be awarded only in Canadian currency, and that such judgment may be based on a rate of exchange in existence on a day other than the day of payment. Now, the point about a currency conversion clause, and there's an example attached to the memorandum as Schedule B, is to deal with the latter part of the exception. That is to say that a judgment of a Canadian court being awarded only in Canadian currency may be based on a rate of exchange in existence on the day of judgment or some other earlier date. What the currency conversion clause seeks to do, among other things, and without getting into it in any detail, is to deal with the question of res judicata and deem a continuing cause of action to arise until the full amount is recovered based on the contract between the parties. Any thoughts on that clause and exception, or not necessarily the clause, but the exception and the legal principle?
I guess is the general legal principle that the rate of exchange applied by the judge would be that in effect at the date of his order?
That's the problem.
So that then the purpose of this clause is to contractually say they'll also pay any adjustments that result from further changes between the date of the order and the date of actual payment?
Yeah, that's right. That is correct.
I guess that becomes an interesting question, having to fix the amount owing by judicial order, whether or not the contract is spent or whether or not you could still sue on the contract.
That's right.
Mr. Coleman's determined, as a matter of public policy, the court will give effect to the contract and will not say that, well, as a matter of public policy, we won't enforce this. Like it's a nice question. It's where you have to think about enforceability. I like the use of the word clause. It goes on for a page and a half. But I looked at this sort of thing before, and what it provides is that when the court has given judgment on the first trial, the parties have contracted for a right to receive a second amount in the event that the exchange rate doesn't provide the full amount at the end of the first trial. And I think the court today would enforce that in a commercial transaction. I know there's some judgments down in Quebec, I think it is, and there's one that provides trouble, but I think the court would go along with it.
Would they do it in their original order, or?
I believe they would, Purdy.
I haven't read this clause carefully enough, but it seems to me it only goes up and doesn't go down.
No. I thought Gordon was very generous. It said, or let you a less amount, somewhere in the page and a half.
Okay, accept that. If it only goes up, the court might order otherwise.
Yes. In
order that it could go down as well.
One of the areas that has sort of bedeviled the giving of legal opinions lately is our questions arising with respect to the Personal Property Securities Act. And beginning at this page 190, there are several examples of the kinds of qualifications which might, I stress, be appropriate in connection with the PPSA. One exception that seems to have crept into legal opinions singles out the fact that there are procedural steps which have to be taken, one of them being, of course, a 15-day notice requirement which triggers buyout rights of others in respect of a secured creditor's position. And this right, or this procedural step, has triggered the formulation of the words which appear in 190, subject to the reservation that under the PPSA, the procedures for exercising certain remedies provided in the pledge agreement in this case may be affected, but in our opinion, the said act will not affect the validity of the pledge agreement or make impractical the realization of the benefit of the security. Well, you can tell, I think, probably from the way I've written it and the question that I ask at the bottom of the page, that I don't necessarily agree that that is an appropriate qualification, that there are any number of procedural steps which have to be taken in connection with the enforcement of security, may have to be taken in terms of realizing on a judgment which we don't elaborate on, and so why single this one out? Any thoughts?
I agree, Gordon. I guess I'll ask you a question since I don't know much about the Personal Property Security Act. How is this different than any qualification affecting creditors' rights?
Well, I think it's different in this respect, that it zeroes in on a procedural step that would have to be taken in connection with the exercise of remedies. And as I say in the brief commentary, does it differ significantly from being required to pay a $10 filing fee or anything else?
I think this is the kind of thing that I referred to earlier, that once you put this in, you can, if you really sit down and have somebody do a lot of legal research, you could think of 20 more things to put in.
Exactly.
And it's a conundrum which we'll come to at the end of this discussion, I guess.
And similarly, not losing sight of the fact that these things are supposed to be written to be helpful for the addressees of the opinion, I would think that the lender or whoever would have every right to say, well, what do you mean procedural steps? I mean, what are you saying? Are you really trying to tell me something here? I don't know what those words tell the addressee. Another question that arises in connection with the Personal Property Securities Act is the question of proceeds. The registration of a financing statement with respect to collateral covers the proceeds of realization of the collateral, subject to the traceability point that's alluded to on this page. But there are certain types of collateral which can only be perfected by possession, such as the pledge of securities, and where there is no financing statement registered, which of course would probably be stupid. One would have to deal with the question of the protection of the proceeds. Similarly, where a security interest is, securities are pledged, one must take account of subsection 27(2) of the PPSA, which provides that there's no perfected interest, security interest, in proceeds which are not identifiable or traceable. This may be a pretty arcane observation and be of the same ilk as the limitation on specific performance in connection with an obligation to pay money and only to pay money, because obviously if the proceeds from the sale of pledged securities can only produce money, one would think that by definition they're identifiable or traceable.
Gordon, I had trouble with this, and I'll confess to you, I didn't focus on it earlier and have an opportunity to say something to you, but as I read this, we're saying a further point related to opinions, proceeds, relates to the fact that 27 provides there is no perfected security interest in proceeds that are not identifiable or traceable. This provision would seem to require a qualification as follows: provided that the proceeds of the debenture...
That really should have been the pledged securities in parentheses.
Okay.
Okay?
So then you grab something and you sell it.
Yeah.
Well, if the money's in a bank account, hopefully,
Yep.
then you might have an opportunity to get it.
Yep.
Okay. Except that the note I made up earlier on the page was, if you got to register, you better register.
Absolutely.
Yeah.
Both of those points are really raised. Number one, the second one on a traceability, I think is sort of, as I say, somewhat arcane. The other one, I think, just simply says register.
Yeah.
Another qualification that's becoming common with respect to the PPSA relates to the point mentioned earlier, and that is that possession of collateral by a secured party perfects security interests in certain property, and only possession does so. And the formulation of the exception, it relates to that fact that possession of collateral by a secured party is the only method whereby a security interest in certain classes of personal property may be perfected. Now, one of the other areas that has been with us for many years is the question of what can you say about a floating charge. And we've broken up this topic into registration against real property, the whole question of after acquired property, and the requirement from lenders that the borrower's counsel are opine that the charge constitutes a, quote, first, quote, floating charge. With respect to the registration of a floating charge against real property, which is sometimes done, take, for instance, a trust indenture which provides for an issue of debentures in series from time to time, with the floating charge creating a charge on the undertaken property and assets of the company, which, as we all know, is a charge which hovers over that undertaken property and assets and crystallizes only upon the happening of an event of default. Sometimes the trust indenture, which contains the principal indenture, which contains the floating charge, is registered against the real property. Query the meaningfulness of this. And the words are given here which relate to the fact that registration of the debenture does not necessarily have any significant effect. The words are, we express no opinion as to the effect of the registration against the real and immovable properties. Should the floating charge crystallize, a further registration against the title should be effected to ensure the effectiveness of the security as against persons who would otherwise be protected by the provisions of a statute relating to the registering of instruments against title, the theory being that the floating charge creates no interest in the real property to be registered prior to crystallization.
I just don't agree with that.
Don't agree with that?
I don't think so. Like, unless the law has changed, but if you know, what is the nature of a floating charge? You have to make up your mind what that is. If the corporation owns real estate, what must you do in order to protect your clients? I'm going to use the word interest loosely now, in the assets of that corporation. It seems to me, or at least I think our firm used to and still follows the practice, if you want to be protected in respect of that floating charge as it relates to real estate, you file or register a notice against the title of that land. Now, I don't understand the business that after a crystallization you must do another registration. There are a whole lot of things you'd have to do after a crystallization. And, why talk about it in the opinion?
Well, one of the things that flows from that crystallization, of course, is that now you have a fixed charge.
Fine. Do I have to register again? And if we do, we'll do it. But the day I write the opinion, I'm not thinking in terms of or we're not advising people what you have to specifically do to enforce the thing.
Let me ask state what the law might be. I'm not much of a real estate lawyer, so I'm subject to qualification, but if you register, can you register first of all in the land titles or registry office your floating charge?
With an appropriate description of the land, they will take the registration of a trust indenture.
So
or supplemental.
you registered something that's floating above the land or whatever.
That's right.
So that if a subsequent potential mortgagee of that real property will find the registration of the floating charge, he will look at the exceptions permitted in terms of mortgages to the floating charge, and if he's an exception that's permitted, then all he'll worry about is whether or not the charges cease to float, I guess. What does he do to find out if the charge is no longer floating but is crystallized?
Well, to take the even, I guess, more drastic situation where the fixed mortgage is entered into contrary to the negative pledge provisions in the trust indenture, and the mortgagee
Has notice.
has notice of it. I think what we should do with this one, gentlemen, since we have such a bevy of real estate lawyers here, is let them inform us with their questions.
Ask someone who knows, eh?
Well, the question is, doesn't the debenture usually contain a fixed and as well as a floating charge? And the answer is not necessarily. Indeed, in order to preserve the flexibility for companies who can borrow without creating a specific charge against property, one often does simply a floating charge debenture, which allows the company to buy and sell property in the ordinary course, and do so freely so long as the company is not in default under its obligations. So what we're talking about here for the purposes of this example is a security constituted by purely a floating charge. Well, there would be a description to register in the trust indenture.
I'm just wondering if the question isn't what's the rules under the Registry Act for priorities, because I can see that your negative covenant would constitute notice, but is there such a provision under the Registry Act that gives priority to a floating charge?
Not to my knowledge.
So it doesn't serve any purpose then to put it on title.
I think it's a matter of giving notice. And there's often a so-called negative pledge in the trust indenture. It says you won't mortgage property to secure another creditor, so.
Having received notice, and if there is a negative pledge, where does the mortgagee stand if he go ahead and takes a mortgage and he knows that the mortgagor is violating the negative pledge?
Can you rely on the Registry Act for the determination of priorities, irrespective of this notice?
That's a question I
No, I
throw
think
out
the
to all these
answer to
real
that-
property lawyers that preceded us.